Good morning, everyone. I have never done a webinar before, so it is a little weird to stare at a computer screen and talk to 35 plus all at the same time. So if I fall into my typical habits of asking questions like, by a show of hands, how many of you have had this happen, I recognize that no one will be raising their hands, and if they are, I won't be able to see them. So I will just keep moving on, and I'm looking forward to this morning. The topic we're talking about today is titled Beware Contractors, Changes at the Register of Contractors. I've been practicing here in town for a little over a decade, and I will tell you that the changes that have taken place in the last 6+ months are significant changes. Some of them multi-decade differences than what there were 2 or 3 decades ago. Which is why I felt so passionately about this being an important topic to be covered in a webinar. I spent a couple hours with the director and their chief legal counsel and their chief of staff, in particular about the complaint process, because I wanted to make sure what I learned was accurate versus secondhand with a little bit of spin. So what you'll be getting from me today is as accurate as I can with as little spin as can be tolerated. So we're going to cover 3 topics this morning. We're going to talk about the changes in the ROC complaint process. We're going to talk a little bit about the changes in the license classifications. And then we're going to talk about whatever happened with the background checks and financial disclosures. There was a huge issue a number of months ago, a lot of focus and attention, a lot of lobbyists got excited, and I want to kind of come back and circle around and explain where it ended up. So first, let's talk about the complaint process. I'm sure any of you who've spent any time in the construction business, either yourself was the target of, apologize, my computer's going to take a moment, there it is, the target of a complaint, or knew someone who was the target of a complaint, or you were at a trade association mixer and someone was griping about receiving a complaint. The ROC complaint process for the last number of decades was a complainant-driven process. So a stereotypical process would be one where let's say a homeowner would sue a contractor, would file a complaint with the ROC against a contractor. The ROC investigator would come out and explore the process, and ultimately whether a citation was issued or not was not in the hands of the ROC, but was in the hands of that homeowner, that complainant, whether or not the ROC found merit in the claims. Now, almost a 180-degree shift. Now the ROC will decide, once a complaint is made, whether the evidence provided by the complainant or gathered by the ROC investigator warrants a citation. Once the complainant makes the complaint, so again using that hypothetical homeowner and contractor, once that homeowner makes a complaint, they lose all control of the process. That's a huge difference, and we'll spend a little time as to why that's important for you to understand. Thought it was important to try to understand why exactly after 3+ decades of doing it one way did the ROC decide it was time to make a change. There's a pretty good reason. Since 1979, at least since 1979, the Auditor General, every time they've taken a look at the ROC, have really beaten the heck out of it. They found, and I've listed some of these things, that the ROC has not adequately protected the public from incompetent, unscrupulous, or insolvent contractors, that the ROC does not aggressively discipline contractors who violate statutory provisions, that a contractor who commits a violation of the statutes is in a position to avoid discipline by resolving its issues with the complainant. So when I first met with the ROC on this topic, they pulled out stacks of these reports where they were pretty much told they were doing a bad job on this angle, and had been now for 3+ decades. They felt as though it was a time to make a change. There might also be other motivations that I'm not aware of, but that's what they're pointing to is the rationale is that after 4 decades of being beaten up about it, it was time to make a change. So again, let's talk briefly about how the old process worked. The complainant decided whether a citation was to be issued, not the ROC. resulting in the ROC being little more than a referee. So again, complaint was filed, inspector might come out, take a look around, might issue a corrective work order. You might comply with that corrective work order. Inspector says, okay, I think we're good now. Homeowner or complainant says, no, I want a citation issued. And the ROC, for the most part, would say, okay. It was an inexpensive way to litigate issues that turned into an expensive way to litigate issues, and it still wasn't in court. You could still be the target of a lawsuit at the same time as you were fighting an ROC complaint. It became expensive. It became a way for some complainants to harass contractors because they had complete control over the process, and you had to fight it all the way out to the administrative law judge. And the ROC recognized, and candidly, I think those of you who've been working in the industry for a while would recognize that we're certainly abused by complainants. It became a hammer, and it was also used sometimes by contractors against contractors as a way to try to influence or create pressure to resolve something. And the reality was, especially when you're trying to chase work, having open ROC complaints does not help you get new work. So the ROC looked at that and said, okay, that's a problem. We need to make sure that the new process resolves that as well. The old process also resulted in the occasional repeat offender continuing to lawfully contract. Now, how would that work? Let's say contractor ABC was out doing work and had a complaint issued against it. Citation perhaps gets issued, contractor retains counsel or is able to negotiate a resolution with the complainant. Almost always, the ROC would dismiss if the complainant and the contractor said, we've resolved this issue. So while, yes, you had a complaint made, you had maybe even a citation issued, if the complainant was satisfied, so is the ROC. Now, on one hand, there's nothing wrong with that because certainly the contract is between the contractor and the complainant, likely. But what it resulted in is that each of these situations were looked at in a vacuum. So rather than looking at the history and saying, okay, well, there's been 5 other complaints made in 2014. It's April, and we're getting complaint number 6. We may have a bad actor out there. All of the previous complaints were effectively ignored. Because, again, if the ROC was going to dismiss if the complainant was satisfied, it didn't matter how many previous complaints existed for the evaluation of the complaint. What that could result in is having the bad apples running around who, so long as they were good at resolving things with the complainant, could continue to move along. So you have both a reason and rationale as to why the ROC was not protecting the general public and also was not protecting our industry. Because while the vast majority of contractors receive few, if any, complaints in a given year, they have and are able to trot out the ROC, some contractors receiving double-digit complaints in a given year. Those guys shouldn't be on the playing field. It is not helpful to our industry and certainly not helpful to the general public. But that's what the old process would allow to happen on occasion. So what is the new process? Now the ROC owns the process from start to finish. Once that homeowner, that complainant files a complaint, they lose absolutely 100% all control of the process. The ROC investigator, an ROC investigator is going to be assigned to the complaint and be given all information available, including previous complaint history. A good analogy for this stage of the process is a lot like the first half of an episode of Law & Order. ROC investigators are now much more acting like a police detective, collecting information for the purposes of review by ROC Legal. They are going to dig in. They're going to ask for information. They're going to, if they come out to a site and they see things that weren't complained about, you might still ultimately hear about it. The issue is no longer confined simply to what the complainant made and their complaint. You're going to be looked at. It's the responsibility of the investigator to determine whether the complaint had any merit. So they're going to be asking for documentation early. So let's spend a minute or two talking about first practical tip in the seminar, because you got to have some things to take away from a legal seminar or you've wasted your money. So here's tip number one. A contractor who's on the receiving end of a ROC complaint should immediately reach out to an attorney. Now, I recognize that I'm an attorney, so that might sound a little self-serving, but I'll explain to you why that's important in a minute. Waiting to see if the ROC inspector decides to issue a citation or other form of punishment may be too late, may invite larger expense and consequences down the road. In the old process, it was one where, okay, the ROC would get a complaint, you'd be notified of the complaint, the inspector would come out, you'd be in a position to try to resolve things with the complainant, the homeowner, and if you got it all worked out, the ROC would go away, and you moved on your merry way. That's not the process anymore. The homeowner being satisfied is a criterion, but is no longer the only criterion for the ROC. So waiting to see what might happen is what I typically used to get. Is I'd get phone calls after the citation was issued. Oh, Matt, we weren't able to get it worked out. Citation's been issued. Now I need an attorney. You need an attorney at the beginning because the inspector is the one who's making that recommendation to the ROC. So figuring out from moment one how much you're going to cooperate with that inspector, what you're going to provide to that inspector, starts then. Because if your attorney, with your support, is able to convince the ROC inspector there isn't anything there, it dies. Because if the ROC inspector doesn't find sufficient merit to a complaint and recommends that nothing be done, it does not matter what the original complainant says. As far as the ROC is concerned, it's done. So there's a much stronger need and role at the beginning of this process for an advocate on your behalf to try to resolve things before the citation gets issued. Tip number two, in the same vein, once you've reached out to that attorney, whoever that might be, you need to collaboratively decide to what extent you're going to engage with the ROC investigator and how best to present your case. Because you can nip the entire issue in the bud by having a strong showing at the beginning. But you need to be mindful that whatever's presented to the ROC does not reflect other violations, because the ROC investigator will be looking for this. An example that I heard about recently is occasionally, under the old process, you'd have two contractors who would, or a contractor would file a no-pay complaint against another contractor through the ROC. And there was an instance recently where two contractors filed no-pay complaints against each other at the ROC. Well, the ROC did not find merit on either one of those complaints, but in reviewing the documentation, found other violations and then ultimately cited them for those. So being mindful of what it is, okay, you've bought off on my notion that you have to plan and prepare and send stuff to the ROC investigator early on in order to try to resolve the dispute without even the issuance of a citation. But you can't just throw it all in a box and send it to them. And a good example that a lot of folks don't remember is there are provisions within the statutes as to what your contracts are to have. And one of them, under 32-1158, I promise it'll be one of the few legal citations I give you today, talks about the minimum elements of a contract, that all contracts after December 31, 2007, in an amount of more than $1,000 entered into between a contractor and the owner of a property. One of those things must be that a provision stated explicitly in your contract that the property owner has the right to file a written complaint with the registrar for an alleged violation. The contract shall contain the registrar or contractor's telephone number and website, and shall state that complaints must be made within the applicable time period. It needs to be of 10-point bold type. Now, I've looked at a lot of contracts. I would not say that the majority of them has that provision in it. But the ROC has been abundantly clear in talking to construction lawyers. If they receive materials based upon a complaint, that's one of the things they're looking for. So again, your complaint might be based upon a workmanship issue or a payment issue or a wide variety of things, but that's a simple thing that if your contract doesn't include the things required by statute to be in it, you should anticipate hearing about it if the ROC gets a complaint issued against you. So here's your takeaway, if nothing else from this webinar. It's going to be worthwhile, whether it be your contract administrator, your lawyer, the person who you've staffed out to learn everything they can about contracts. Make sure you take a look at the contracts you're using. Do they have all of the things that the statute requires? And if you're not sure, feel free to reach out to me or whoever you use for support, because you don't want to get dinged for something like that. Let's talk more about the new process. Upon completion of the investigation, the investigator's written findings and recommendation regarding a citation will be submitted to the ROC's legal department. So again, if you want to use the analogy that I like of Law and Order, they've investigated, they've pulled together the papers, they've examined what you and your attorney provided, they've examined what the original complainants provided, they've taken a look at your previous history. They're then going to prepare a written recommendation to the ROC's legal. And the ROC's been staffing up legal-wise. A couple years ago, they had an attorney. Now they have, I believe, 3 or 4 in-house, and they have about the same number over at the Attorney General's office that they use for the purposes of prosecuting complaints now. So they've been staffing up to prepare for this process. Now, I've asked them this question, and they swear to me that since things are still a little slow, this is the perfect time to do this. If the investigator is being tasked with significantly more than what they used to be, I have to imagine this process is going to move significantly slower than it has already. Because they're now asking this investigator to really dig into everything that they've received and make a strong recommendation one way or the other. And then once that's done, an attorney sitting at the ROC's office is going to read all of this and try to determine what the best course is. That's my long way of saying I have to believe, regardless of what I've been told, this process is going to be longer than what it used to be. Maybe that's a good thing, maybe it isn't. I don't know. But I would not expect these things to whip along. If the investigation reveals no substantial violations from the perspective of the ROC, the matter is going to be closed regardless of the perspective of the complainant. And I think that's ultimately, and the ROC's made a point of pointing out all the reasons why this new process is a win for the construction industry and for contractors. I do think ultimately that is one of the benefits, is while it did not happen all the time, I can at least once a year say I've worked with some contractor who's at least been threatened by some complainant with a complaint that really had no merit and was simply being used as leverage in a negotiation. And now the process is one that the ROC, if they find that there is no merit, are going to close it. Now, that doesn't mean that that complainant can't turn around and file suit in court, but it does mean, if nothing else, that you're not fighting a double battle and incurring the legal expense and the time and the energy and the drama of being both at the ROC as well as in court. So that's a win. Now, upon receipt of the investigator's reports and recommendations, like I said, the ROC's lawyers will examine the findings and evaluate any mitigating or aggravating factors. Those factors are going to include the nature of the claim, the contractor's complaint history, and the contractor's response to the pending complaint. So, as we discussed earlier on, when there was no evaluation of previous issues, we're now again 180. The ROC is going to look at previous complaints. And maybe the previous complaints were all resolved, but they're going to look back at the substance, and they're going to look back to the number, and they're going to try to determine, okay, is this individual have a track record of having problems? How do you respond to these issues? You received this complaint, for example, or a hypothetical complaint, and you ignored it. You didn't cooperate with the ROC investigator any more than you absolutely had to. You told them to go pound sand. You know, they're going to look at those things. They're going to look at the nature of it. Are we talking about some cracks in the drywall up in the corner, or are we talking about, as I saw a couple years ago, windows installed on the second floor of a home that when you pushed on them from the inside fell out? Okay, that not only is that bad construction, that's a safety issue. You know, you're worried about the people walking down below. You're worried about the kid whose room that was. They're going to look at all of those things to try to decide what they should do. And once it's with them, meaning the ROC's lawyers, your lawyer is not going to be in a position to reach out to those lawyers directly, because they're no longer acting as a referee. They're acting in this kind of, they are acting in this capacity of potentially prosecuting. So again, the best time to influence those sorts of things and to provide a number of mitigating factors is when the investigator is doing his work, not after it gets to ROC legal. If the legal department does believe there are violations, they may utilize a number of options to address the concerns. Now, previously, what we saw is a lot of contingent sort of consequences. Please do X, Y, and Z. Sometimes it didn't say please, but it would say do X, Y, and Z within X number of period of days, or your license will be suspended, or your license would be revoked, or this is going to be suspended for 2 days. But there was almost always an unless, because the goal was in part to try to make sure the complainant was satisfied with the work performed. Please remit to complainant $10,000 by X date or. Well, they're no longer necessarily doing that either. We have a number of options, and their rationale is not all things call for threatening of suspension or revocation. And generally speaking, I'd agree. So let's take a look at what some of these new consequences could be. The first is a letter of concern. A letter of concern is going to close the case with a warning. The ROC reserves the right to reopen the matter and could use it as an aggravating factor down the road. Now, I've spent time listening as to what this letter of concern is going to effectively say, and it's going to say, while we don't believe there is sufficient evidence or information that should result in a citation to be issued, based upon what we've seen, we have concerns about what you're doing, and we would suggest doing something different. The headache, and these have already started to happen. The process started to make a shift in the fall of last year. You receive a letter of concern. You have no right at that particular point in time to contest it. So it's like getting a letter put in your permanent file when you went to school. It's in there, and you have no right to say, I disagree with your findings, I disagree with your concerns, let me do this to wash out that concern. You should strongly consider changing what you're doing if they've pointed out a concern, but it's in your file. Again, the reason why active at the ROC investigator stage is so important, because you can hopefully head off some of these things at the pass. Like I said, there's no appealing or responding, and they've gone back and forth depending on when I've had the conversation with them and depending on what room I'm sitting in as to whether these things are going to be reflected on the website or not. I think ultimately they're not going to be, because they've taken the position that since there's not going to be any real impact against your license, the letter of concern is not appealable. If there was going to be an impact, they'd have to give you some sort of right to appeal. Well, they know, and they've articulated that impact on your license in large part comes from what's publicly known, what's on the website. What could a potential general contractor or owner or homeowner look and find out about you? So I don't think it's going to be on the website, but that's something that I'm continuing to monitor. The written directive is a fancier name for what was called the corrective work order. The written directive in a case results in the case remaining open until the contractor complies. Now, the reason they renamed it is, one, I think it's somewhere in statute that it's not corrective work order. The actual terminology is written directive. And sometimes what the written directive might be is, you know, please revise your contract to accurately reflect the language required in 321158. That's not a corrective work order. But they're telling you to do something, and they're telling you to do it, and until you do it, the matter will remain open. So they've renamed it. Part of the wrinkle now is, while it was not always a guarantee, a corrective work order under the old process was such that if you complied with the corrective work order, odds were, unless you were dealing with a harassing sort of complainant, the matter was going to be resolved to everyone's satisfaction. Under the new process with the written directive, it's not necessarily going to be the case. You could comply with the written directive, and based upon the, I'm going to scroll back for a second, the factors that are on the bottom of this slide, the nature of the claim, the correct contractor's complaint history, the response to the complaint. If you have a bad history, if they believe you have a bad history, you might comply with everything in the written directive, and you might still see further action from the ROC. It doesn't mean you shouldn't not comply with the written directive, but unlike the past, it's not a guarantee that you're going to be done with the ROC. Citations. All citations moving forward are going to be issued pursuant to the motion of the ROC, with the registrar as the named complainant. You're not going to be arguing, and you're not going to be retaining counsel to go and argue in front of the administrative law judge the homeowner. The homeowners become a potential witness that the ROC might subpoena if the homeowner decides that they don't want to pursue the matter any further. The ROC is taking the position they will subpoena them if they have to. The ROC is going to bear the burden of proof at the administrative hearing. Now, I'm going to pause for a second. This is a huge difference. Again, in the past, if you settled things, things were done. Now there's a real concern of you attempting to directly deal, or your attorney directly deal with the homeowner or the complainant once the ROC complaint's been made. Let's say you get it resolved, and let's say they say, fine, for $5,000, I'm done, I'm good, or if you repair that window, I'm done and I'm good, and you go out and do that. The ROC is not satisfied, which is now the only one that really needs to be satisfied under the process, and they acknowledge that that's the case. You might still be fighting an ROC issue. And that homeowner who told you they were going to be satisfied still might be compelled to testify at an administrative hearing. It's a different process. Something new. Respondents to the complaint may request a settlement conference to attempt to negotiate a resolution with the ROC. So the ROC has not completely gone off into the realm of let's prosecute and go after these folks. They do recognize that they can't realistically handle all those things to hearing. So they've pushed real hard to advise contractors that you could, if a citation gets issued, request a settlement conference. And they've expressed pretty clearly that's their preference. So much like the old process allowed you to hopefully resolve things with the homeowner, you are still going to be in a position to resolve things. It's just going to be with the ROC. Now, an interesting, weird quirk to that, the homeowner has, or the original complainant has little to no say about that resolution. So again, you're negotiating directly with the ROC, and if the ROC is satisfied, regardless of whether the original complainant is there or not, whether or not the homeowner is there or not, you're done. They've definitely taken ownership of the process, and they strongly encourage folks to go down that process. Speaking with the head attorney general for the prosecution of these citations, they're overwhelmed already. Not because there's this huge push of new ROC complaints. There's only so many people to go around. And it's one thing when the complainant was responsible. A complainant might hire an attorney here in town. There's a lot of attorneys here in town. Plenty of staff to help with that. There's plenty of attorneys that work with contractors, plenty of staff to help with that. They have 3, I believe, assistant attorney generals doing this for the ROC. Also means if a citation ultimately gets issued and it's not settled, it's going to be a long process because they're already drowning in what they have. And as we all know, the industry is picking up, but it's certainly not back at the fever pitch that it was. The ROC is not going to issue a citation unless they're seeking a suspension or revocation. That's also helpful to know, I think. That if you get a citation, they're not looking for you to hop through a hoop or two and be done. Unless you're able to get it settled, and those are the 2 things they're seeking. They're either going to seek to suspend or revoke the license. So let's do a little recap on the process. I know I've said it probably 5 different ways, but it's worth saying one more time. The game has changed. An attorney in our office wrote the chapter of ROC complaint process and litigation for the construction law guide, the statewide thing pushed out from the state bar. And her and I looked at it shortly after I did this research, and you can pretty much recycle the whole thing. It is a completely different process. And my recommendation to clients are some of what was in here. You want to call your attorney, your advocate at the beginning, immediately upon being notified, versus waiting to see how it plays out and trying to handle it on your own, because the ROC doesn't have attorney's fees to worry about. They are in the business of moving these things along as best they can, and they're going to prosecute them if they see things. So you want to immediately engage counsel. The ROC is no longer the place to inexpensively litigate disputes. I've certainly seen instances in the past where one contractor or another got crosswise with the other contractor, and let's file ROC complaints, and it's a quicker process. We can move this thing along. We're going to try to get this thing resolved and settled. This is not where you want to go. You want to go, I would tell a contractor, you want to file an ROC complaint if you genuinely believe there is an ROC violation that is worthy of investigation and potential citation. But you don't want to flippantly file an ROC complaint. It creates a snowball that once you file it, you no longer have any control over. Here's another interesting thing about this process. The findings by the administrative law judge. I don't like to put a whole lot of acronyms and things, but the ALJ stands for administrative law judge, against the contractor. So let's say this issue goes all the way through a hearing, an administrative law judge hears the evidence from the ROC and finds against you as a contractor. That could be binding against you in court. Now again, remember, it's not the original complainant that is at the ROC, but that original complainant, if they decide to sue you, could take that administrative finding and it could be binding against you. The court could use that as very strong evidence that there was a violation. Here's the flip, and it seems unfair, and I think it is unfair, but nonetheless, here's the case. Let's say you win at the ROC. Findings in your favor are not necessarily binding because you're not arguing against the original complainant, you're arguing against the ROC. So you could go through the entire process and win, and then have to go through an entirely different process against the original complainant in court.
We do have a question, Matt.
Great.
We are dealing with a major case that is being heard by the ROC in May. We have been involved with the old rules process for 4 years now. We have incurred over $50,000 in attorney's fees. Can this hearing be deferred in order to follow the new rules? This case involves extreme harassing and interference by the complainant.
Well, first, I'm sorry that you're going through that, because that is that's part of the whole reason why the ROC has argued that they made some of these changes, is that there are circumstances that exist like this. My understanding, and I'd certainly be willing to follow up a little bit on it if you wanted to reach out to me offline, is the ROCs took the position that matters moving forward from, I believe it was last October, would be under the new process, and that anything that was already in the queue would stay with the old process. So I don't believe that's going to be an option. But again, if you want to reach out to me offline, I'd be, if nothing else, willing to reach out to the ROC and ask that question of them directly and get that answer back to you. And good luck. There are reasons why this change took place, and hopefully that will help reduce those things from happening. So I promised to talk about a couple other things. Obviously, we spent a lot of time on the ROC complaint process because, one, I thought there was a lot of meat to it, and I thought there'd be a lot of interest. Let's talk for a few minutes about the changes to license classifications. The legislative year also started off with this, the notion that the ROC felt as though there were too many license classifications. There were 238 to be precise, significantly more than neighbor states. I believe I was told that California had just a little over 100, maybe 120. Nevada had a similar sort of number. We had a lot of classifications. And so they were, as an agency, very interested in trying to reduce down those number of classifications. They significantly did so. There was a lot of consolidation. Effective July 1, 2014, classification of roughly 25% of licenses, existing licenses, are going to change. One of the larger changes is the consolidation of many commercial and residential licenses into dual license. And if you're interested, I don't have it as a PowerPoint slide, but the ROC put together, and I'd be glad to share it with anyone who wants to reach out to me, a summary of the changes of the license classifications. The reason I didn't put it up on the slides is it's about 8 or 9 pages, but it has a pretty decent chart of showing what a current license was and what the license would be effective July 1. So let me know, reach out to me, you'll have my email address at the end. The ROC website also has a pretty good breakdown of how you might be individually impacted. You're going to want to take a look at this if you haven't already and make sure you understand how your licenses might be impacted. A couple general comments. For the most part, license fees are going down. Not all, but for the most part. The 25% whose licenses are being impacted, their fees are generally going up. And the majority of bond amounts are also going up. So on one hand, it sounds great at a mile-high level that we're going to reduce down the number of licenses. It will allow for some streamlining of the process, some clarity of the process. But oh, by the way, there's going to be some of you who will be paying more for your license, and almost all of you will be paying more for your bonds. But let me know offline if you'd like me to send you that summary or take a look at the ROC website for how you might be individually impacted. Yes?
We have another question. In your opinion, how will the ROC changes impact commercial construction subcontractors the most?
Oh, that's a really good question. I would say out of the changes that we were discussing and the ones that we'll wrap up with in a few minutes, it's going to be the complaint process. It's going to be understanding when those complaints get issued, because while I would say that there's a large percentage of them anecdotally that are residential, there's certainly commercial subcontractors who are the target of these things, and it is a very different process. I would say number two is definitely the fees and understanding and also looking and seeing who might be coming into your space. Because now some of these folks that might have been only, for example, a residential sign contractor is one of the examples in their summary of rulemaking, will now likely have a joint residential and commercial sign license. So someone who used to only play in one space is now potentially going to be coming into your space as well. So those would be the two top things that I think are going to be most important to take away from this or from the rule changes. Hopefully that answered the question. I was telling Erica before we got started that I typically look at the room and watch for nodding heads or sleeping heads, and what I have is a phone and a screen. So I'm glad there were some questions, because if nothing else, there's two of you out there that stuck it out with me. So what happened with background checks and financial disclosures? Also early in the legislative session, there was a huge, I'll use the kind word brouhaha. The ROC was trying to revise how it approached background checks and how it was going to get financial information from everybody. And you would have thought that Edward Snowden had shown up in Arizona. It felt very much like an invasion of privacy. There was arguments that it was an invasion of privacy. The background check form was a standard form from a website the ROC was intending on using that asked and theoretically would have allowed the ROC to dig deep into a person's background. And it felt very invasive. And as a third party sitting to the side, I could understand that perspective, that some of the questions and some of what it appeared the ROC could dig into did feel invasive. And so what the ROC told all of us was that they were going to modify the form and cross out the offending language, and to my knowledge, that's what ultimately ended up happening. Yes?
We have another question. Does the ROC handle complaints on federal projects that may involve contractors from other states?
Does the ROC handle, read that to me one more time.
Does the ROC handle complaints on federal projects that may involve contractors from other states?
The answer to that question, I believe I have the correct answer, so I will put the caveat out there that I have not handled an ROC complaint in that process before. I believe if the federal project exists in Arizona, the Arizona Register of Contractors tippy-toes into the process, but does not have full authority to deal with contractors from other states, because the way the federal contracts are worded, so long as the contractor is licensed somewhere, they can work on federal project because it's a federal reservation. So that, I believe the answer is no. They will occasionally try to raise concerns if concerns are made to them, but if it's truly a federal reservation, a military base, etc., the ROC tends to stay away from that. I'm about 90% sure on that, but I will take a look and email you offline if I come up with a different answer. So the other piece that came up was financial disclosures. And there was a form that was circulated around with the notion that a contractor would fill this out up front before there was an issue or concern raised against the contractor, which they would then, meaning the ROC, would then be able to send off to the Department of Revenue in the event there was a complaint made at some point in time down the road that you were not paying your taxes. Now, that explanation of the issue felt about as convoluted as all the circumstances surrounding it. One of the things within the Arizona statutes that the ROC was required to suspend or investigate a contractor for was failure to pay income taxes, withholding taxes, or taxes imposed and incurred in the operation of the licensed business. Well, they had no good means of doing so. At least this is what they professed. The Department of Revenue was unwilling to share information. You typically would not be, if you had a complaint issued against you, would not be willing to share information readily. And it became this catch-22 where they were required to regulate it in part, but they weren't in a position to do anything about it. So they raised this notion of this form as a prophylactic way to have the authority up front. He's asking you for the authority to get a one-page financial information sheet from the Department of Revenue after a complaint was made against you was not very likely. So they were trying to get it up front before a complaint was made. That scared a heck of a lot of people, and candidly, I was one of those people where here's all these authorizations sitting around. So ultimately, there was a move to revise the statute to remove that from the ROC. The Department of Revenue was in a much better position to both investigate as well as punish a business owner with the revocation of a business license for failure to pay taxes. What ultimately ended up happening, and here's my other citation for the day, SB 1160, Senate Bill 1160, removed the obligation from the ROC to investigate that sort of issue, but instead added that the registrar would temporarily suspend or permanently revoke the license issued to a person under this chapter upon notice from the Department of Revenue that a tax debt related to income taxes had been not paid or refused to be paid. So instead of placing upon the ROC this obligation to investigate whether or not you as a contractor were paying your taxes, they're in a position to suspend or revoke a license if the Department of Revenue ultimately comes across you, has a tax issue, and you fail to pay. So it resolved the issue of financial disclosures with the ROC, but happily still left with the ROC the ability to revoke contracting licenses for folks that are bad actors out there that aren't paying their taxes. That is what I promised to cover over an hour. I think we covered it, and it looks like we are just at the right time. It's 10:02. I apologize that I went a couple minutes long.
Oh, I have 9:56.
Well, fantastic. Then I brought it in right on time.
I just wanted to mention a couple things really quickly. I understand we had some audio difficulties at the beginning of the presentation. That is probably because of my phone. So I wanted to just go over one more thing real quick. And that is, if you had any additional questions, you can send those in to us. Here we have one that just came in. You can answer this while I get this up. Well, actually, let me go over how the questions are asked real quick. So if you have a question that you would like to send in here at the end, feel free to, on the right-hand panel, enter it in the question box. You should see a question box on your right-hand side, and you enter it in the section that says enter a question for staff right here. Sorry, I keep clicking the slide to illustrate. Going through slides here. So if you have any additional questions, please fill those in. If you have to drop off, I understand that. We do have one question that just came in for Matt, and it's when does the financial disclosure become effective?
That's a good question, and I perhaps was a little unclear. What ultimately ended up happening is the ROC is not going to be asking for financial disclosure forms to be filled out by contractors. And they're not going to be in a position now, like they were, at least legally in the past, obligated to investigate a licensed contractor if a complaint is made about failing to pay taxes. Instead, what's going to happen is if the Department of Revenue and a contractor are engaged in a dispute about taxes, the Department of Revenue is going to be in a position to advise the ROC that upon a final resolution that a contractor has neglected to pay or refused taxes, that the ROC will be in a position at that point to either suspend or revoke a license. And it's important to clarify, and that's why I appreciate your question. It's going to be in the event that the Department of Revenue decision is final. So if you're working with the Department of Revenue, you have a tax dispute, the Department of Revenue is not in a position to advise the ROC and the ROC to take action. It's only after that process that the Department of Revenue becomes final. So there won't be any financial disclosure to the ROC. Instead, they'll be waiting to hear from the Department of Revenue on tax issues.
Okay. And we have one more question that was just for me, something I covered in the beginning but wasn't heard because of audio difficulties. We are going to be sending out copies of the slide presentation to everyone that attended today. We also are going to be having a 5-question survey that pops up at the end of the webinar. If you could fill that out, we would really appreciate that. I'm going to do one more quick check for questions. And I have a couple here. Okay. How will the contractor be checked to be sure his bond limits are appropriate for his gross receipts?
That's a fantastic question. Your bond limit is going to be examined based in part on your license and based in part upon the information you provide. And so the best place to start is going to be going to the ROC website and taking a look at under what license classification you fall and determining generally where your bond might be going. They do have a pretty good breakout based upon the amount of revenue, what your new bond amount might be. And if you have any questions after taking a look at that, please feel free to reach out to me directly.
Okay, we had a request to put your contact info back up on the screen, which I did. So everybody should be seeing Matt's contact information. You can feel free to email him and call him at the contact info provided. We also have just a couple more questions. Years ago, the ROC required that a contractor provide verification that a corporation was in good standing prior to reissuing a license. Do you see this happening in the future?
Yes. I think the ROC is going to continue to expect to have that sort of verification that your business is still in good standing during your renewals.
Okay, and then I think we needed a clarification on the question about specifically when a contractor is renewing their license. I think this was about the financial disclosure question.
Yeah, I will. Again, they're not going to be asking for financial disclosures. That was something they were planning on doing. They were planning on doing that at the renewal. And what I've been told is they're no longer doing that because now they have that the intention is to use this process. The bill that I referenced to you is on the governor's desk and is expected to be signed, but that they are not moving forward with having a financial disclosure form filled out at the beginning.